Dear students, welcome to week 14, module 3 on the International Criminal Court. I propose to give you the historical context and the positive features of the Rome Statute of the International Criminal Court, the negative features and some recent developments, and also critical evaluation of the International Criminal Court. First, the historical context. In fact, at the end of the Second World War, the victorious Allies established an international military tribunal at Nuremberg called Nuremburg Tribunal to try the alleged war criminals, Nazi war criminals. And in the following year, in 1946, there was an international military tribunal for the Far East called Tokyo Tribunal was established. And in fact, in the Nuremberg Tribunal broke several new grounds, and in the judgment there is a serious or important assertion that crimes, international crimes are committed by individuals and not by abstract entities. For instance, a state is an abstract entity. Just because certain crimes happened in Germany, you cannot tar all Germans with the same brush. In fact, these crimes are committed by particular individuals, be it leaders of the or heads of state or government, or the military commanders, or those who execute their orders. So, for the first time, the Nuremberg Tribunal recognized, asserted, emphasized the individual criminal responsibility and said these horrible crimes are committed by individuals and only by and not by abstract entities, and only by punishing these individuals can the cause of international justice, international rule of law can be advanced. And in fact, in the few years later, in 1948, Genocide Convention was adopted by the United Nations General Assembly. It defined genocide in the very first article, Article 1, and it mentioned a series of acts when committed, whether in peacetime or in conflict time, and with an intent to destroy a national, ethnic, religious group, and by carrying out a series of acts, and in fact they have criminalized genocide. And the Genocide Convention says the crime of genocide can be tried by a tribunal within the state where this crime has occurred, or by such international penal tribunal as may have jurisdiction. In fact, way back in 1948, a provision was made for an international penal tribunal to try horrible crime such as genocide. But for long period, the prospect of a international judicial organ to try that serious crime did not materialize. In fact, it was not until 1998, that is 5 decades later, the International Criminal Court statute was adopted. In fact, in between there were several developments. In fact, in 1948, the UN General Assembly, while adopting the Genocide Convention, also asked the International Law Commission to work on the codification of crimes and etc. But because of the Cold War rivalries, because of the lack of agreement, this work remained in limbo for a long period. And all of you are aware of what happened in former Yugoslavia. And in response to those ethnic cleansing, in response to serious human rights violations, the UN Security Council, acting under Chapter 7 of the UN Charter, established an ad hoc International Tribunal for the Yugoslavia. And in the following year, again there was a similar genocide in Rwanda, and in 1994, again the UN established an ad hoc international military tribunal for Rwanda to try serious violations of the international human rights law, international humanitarian law. Mind you, these tribunals had a number of limitations. They were supposed to take up crimes which happened during a particular time frame, let's say 1st January to 31st December of 1993. They also had a geographical limitation, that in the sense that they could try crimes which occurred in a particular area. So, these temporal, spatial limitations were there, and there were other conflicts as well, and there were other serious human rights violations as well, and every time UN could not summon its collective political will to establish an ad hoc military tribunal, and it also got a tribunal fatigue. And so, the need for a permanent standing international court to try these horrible crimes was felt, and that is how at the diplomatic conference which was held in 1998, the Rome Statute for the International Criminal Court was adopted, and today 123 countries are parties to the Rome Statute. And in fact, on 1st July 2002, that is 4 years after the adoption of Rome Statute, the International Criminal Court came into force. In other words, anybody who committed a crime after 1st July 2002, which is defined in the court's jurisdiction, will be liable for prosecution. And in fact, it is headquartered at The Hague in Netherlands, and it is not an organ of the United Nations. It is not a subsidiary organization of the United Nations. On the other hand, it is an independent one, and it maintains a cooperative relationship with the United Nations. And it is a first permanent court at the international level to try serious crimes. What are the crimes which are covered by ICC? The ICC will have jurisdiction over the crime of genocide, war crimes, and crimes against humanity, and the crime of aggression, which have been defined in detail in the Rome Statute. In fact, I request you to please see the e-text and read what are meant by each of these terms. And now, what is the trigger for investigation? There are three ways in which the court's jurisdiction can be triggered. First, a state party to the Rome Statute can refer a particular situation in its territory to the ICC for investigation. Second, the United Nations Security Council can refer any situation to the ICC. Thirdly, the prosecutor has a proprio motu power on the basis of information brought to it by non-governmental organizations, by individuals, and in this case, the prosecutor has to take authorization from a pre-trial chamber and thereafter proceed with the investigation. These are the three ways in which ICC's investigation can start: A, state party referral; B, Security Council referral; C, the proprio motu powers for the prosecutor. Now, let me talk to you about the principle of complementarity. In other words, a country in which the crime occurs has the responsibility to try that crime, and the international mechanisms have to defer to the national jurisdiction. But in case a country is unwilling or unable to try these crimes, then the ICC can step in. What do you mean by unwilling? For instance, because of the political considerations, if the state doesn't wish to prosecute certain category of criminals, then it comes to unwillingness. For example, you imagine Serbia under Slobodan Milosevic. Serbia during Slobodan Milosevic would not have the political will to prosecute all the Serbian persons who are accused of war crimes or crimes against humanity. Second, inability. Let us say a genocide of the magnitude which happened in Rwanda has there was a massive killings, millions of people perished in a short span of time. Along with them, courts, prisons, police systems all perished. In other words, there is a failed state. Even if it wanted to prosecute these alleged perpetrators of the genocide, it was not in a position to do so. Here is a case of inability. So, the ICC has to allow a country which wants to say that it would like to try a particular crime, but in case if ICC makes a determination that it is unwilling or unable to do so, then ICC can step in. This is what is called principle of complementarity. Mind you, these crimes which I am talking about, genocide, war crimes, crimes against humanity and crime of aggression, are of so serious crimes, they are egregious crimes. The legal threshold is so high that this court is regarded as a court of last resort. Dear students, we have seen how ICC's jurisdiction can be triggered by a state party referral or by the UN Security Council referral or by the exercise of the Proprio motu powers of the prosecutor under certain conditions. Now, currently there are 11 situations which are under the investigation under these three mechanisms. They include Uganda, Democratic Republic of Congo, Central African Republic, Mali, Sudan, Libya, Burundi, Cote d'Ivoire, Georgia and Kenya. In fact, in one case concerning Lubanga Diallo, the International Criminal Court delivered a landmark judgment. In fact, it held as a war crime the use or conscripting of children below the age of 15 years and using them in the in an internal conflict as a war crime, and so it has sentenced Lubanga Diallo to 14 years imprisonment. Currently, he is in the custody, and this pre-trial chamber's decision was upheld by the appeals chamber, and it is a landmark judgment regarding the proscription or prohibition of the use of child soldiers in theatres of conflict. There are a number of positive features of the Rome Statute. These include conferment of proprio motu powers on the prosecutor despite reservations by many states, codification of the crimes of humanity, and sexual crimes have been included in the Rome Statute. So are provisions providing for penalties and reparation to victims, and there are measures for victims and witnesses for their protection. Now, there are other, of course, positive features. On the flip side, there are a number of negative features. These include complementarity provision. For instance, a state can claim robust or functioning judicial system and may indulge in a sham investigation, and which goes on for years together, during which process crucial evidence may be lost, people may die, victims and witnesses may disappear. So, in the end the justice can be elusive. So, complementarity provision is a negative feature. There is a higher jurisdictional threshold for war crimes as well as crimes against humanity, in the sense that there are higher evidentiary thresholds for establishing these crimes. And then there is a 7-year opt-out for war crimes. For instance, you have a statute, you define these crimes, and in the same statute you cannot provide an escape route. You cannot say a country may opt out of the jurisdiction of the court over the war crimes. So, there, in order to get as many ratification of countries as possible, this 7-year opt-out clause was provided in the Rome Statute. Of course, there are many other negative features. I request you to see the e-text for further details. Dear students, let me now give you a brief overview of certain recent developments, the significance of ICC, and also the critical appraisal of ICC. After a long wait, the ICC will exercise jurisdiction over the crime of aggression with effect from 17th July 2018. In fact, as you know, Rome Statute was adopted in 1998, and so now it's nearly 20 years later, the ICC will have jurisdiction over the crime of aggression. Now, as far as certain, the ICC ushered in a paradigm shift. For example, for long there had been standards setting, norm development, conventions adoption, etc. For the first time you find a paradigm shift from standard setting to enforcement, from movement from a culture of impunity to a culture of accountability and towards rule of law. And on the flip side, there are many scholars who say that ICC has become an Africa-centric court. If you see the situations which are before the International Criminal Court, most of them are from African continent, and which did not go well with the African countries, which threatened to go out of the Rome Statute of the ICC. And so there are of course criticism that it is after small and medium countries, or it is only taking up the actions of non-state actors. And the role provided to the UN Security Council is also a cause of serious concern among many states. UN Security Council, as you know, is a political body, and how can it have a role in legal affairs is a question. And as you know, Security Council can refer a matter and also can defer investigation by an year, and which can be repeated year after year. So these are some of the issues which are of concern. On the whole, for the first time, there is a big watershed movement in the history of human rights, and there is a permanent institution which is there and which can try serious crimes such as genocide, war crimes, crimes against humanity, and the crime of aggression.